Good morning. My name is Alex Taylor, and I am the Manager of Communications and Digital Marketing at NC Tech. For those of you who may have not heard of NC Tech, we are the unifying voice for the tech sector in North Carolina, with pillars of work being in talent and workforce development, peer networking, government affairs, and advocacy, and then also just general convening in the tech space. If you would like to learn a little bit more about NC Tech, feel free to go to nctech.org. We are excited to partner with Garfinkel Immigration Law Firm this morning for this virtual workshop on new and proposed regulations about H1B visas. A couple of housekeeping items before we get started. This session will be recorded, with the recording of the session being sent out to all registrants after this session concludes. We will have time at the end for some questions, so please submit any questions throughout the presentation to the Q&A function at the bottom of your screen. We'll try to get to every question at the end of the presentation. Now I'd like to introduce Nam and William from Garfinkel Immigration Law Firm to get started with the presentation.
Hello, good morning. Thank you all for joining us today. As Alex noted, my name is Nam Douglas, and I'm here with my colleague William Crotty. We're from Garfinkel Immigration Law Firm. We are based in Charlotte. Just to give you a little background on our firm, we are in our 28th year. We are one of the largest law firms in the Southeast, and we are dedicated solely to the practice of immigration law. We represent businesses and individuals from more than 50 countries. Our corporate clients include quite a variety of different types of industries, from hospital and healthcare to clinical research, manufacturing, many universities and schools, technology companies, and a variety of small businesses as well. Just a little bit about me. Again, I am a partner here with Garfinkel Immigration Law. I've been practicing since 2011. I come from a 10-year business experience doing community economic development, particularly in the rural parts of North Carolina. So I bring that background to my business immigration practice. I also am an adjunct at Campbell University in Raleigh, and actually lived in Raleigh for the last 20 years, and have been sharing time between Raleigh and Charlotte in the last 4 years. William, would you like to just briefly introduce yourself?
Sure. Thanks, Nam. My name is William Crotty. I'm an associate attorney with Garfinkel, a rare Charlotte native and lifelong North Carolina resident. And I've been practicing immigration law since graduating law school, with a focus on employment-based immigration. I'm part of our education specialty practice group here at the firm, and also do some federal litigation.
Great. Thanks, William. And of course, being the lawyers that we are, we have to provide the disclaimer that this information is just for informational purposes. And obviously, if you have any specific legal questions, we certainly advise you to seek legal counsel, as this is, again, sort of just general information for you to take back to your companies and your businesses in terms of strategizing regarding H1Bs and international students over the next coming year. In terms of the information, so what we'd like to do today is sort of just tackle some general information for you with regards to immigration overview, particularly as it impacts the H1B and F1 international student, what we're seeing on a macro level with regards to changes in policy under the current administration, and then have some question and answers from some specific questions, again, kind of targeting what we're seeing in these changes, and then open it up to you all for additional questions. So to get us started, we know immigration is a huge issue. It has a lot of various tentacles, side areas, and it's certainly something I know everyone has heard a lot in the news. And of course, the nature of our TikTok tweeting and news cycle, everything tends to be condensed and lumped into sort of one overarching idea of immigration. But immigration has a lot of very distinct components. And what I've just done for you here is to break it up into the two largest categories. So when it comes to immigration, you're talking about immigrant or non-immigrant visa classification. Immigrant visa options are where you're petitioning for a spouse or a parent, whether when a company is offering a path to a green card for an employee, when you're seeking asylum as a path, again, to become a lawful permanent resident. Non-immigrant is when you're looking at a temporary lawful status in the US in a particular category based on your eligibility and approval for that particular classification. Generally, work visas, H1Bs, fall into this category, as well as all other non-immigrant work visas. And this is also where international students fall into this fairly large bucket. We'll particularly be looking at, again, sort of school and work visas with regards to this discussion. And then again, just to give you a little bit more context of what those non-immigrant visa categories are. And again, you may have heard of these. You may have some of these foreign national employees as part of your team. But non-immigrant visas, again, we call them the alphabet soup. There is a different visa for every single letter of the alphabet, just about. So this is just a particular snapshot. But again, when you hear people talk about a visitor visa, that's a B1, B2. Investor visas are E1, E2. Again, I've highlighted international students, as well as H1B specialty occupation workers that we'll be discussing primarily today. Intercompany transfers are L. A lot of international companies use this as a mechanism to assign folks from global entities to US entities. There are categories for professional athletes, religious workers, as well as particular for professional workers from Mexico and Canada. So again, particularly each non-immigration work classification allows individuals to work as part of that status. Employment is always limited to the sponsoring company. Non-immigrant visa categories with are categories that must have an employer sponsor. There is not self-petitioning in almost all cases when it comes to non-immigrant work visas. So why are we specifically talking about and wanting to share information with you today with regards to proposed changes as it impacts the H1B as well as international students? And that's because there are huge economic benefits to North Carolina from these non-immigrant visa classification. So North Carolina companies are, of course, just as every other country, state across the country, have employers who are using H1B visas and filing H1B petitions to fill critical roles in their workforce. It ranges from maybe a handful to, again, there are North Carolina companies that filed over 2,000 H1Bs in last year's lottery. Data shows that at least 23 employers in North Carolina each filed 100 LCAs, and we'll talk a little bit more about those. But LCAs are labor condition applications by the Department of Labor and are a required part of the H1B application. So again, this is a resource and a tool that North Carolina companies are relying on to meet the needs of their business, their contractual obligations, and to ensure that they have the best talent available to help drive their business forward. North Carolina, which I'm sure is no surprise given our rich, robust, and highly ranked education system, everything from our community colleges through our state universities, through our private schools, is a key in international students. Again, we rank 14th in the nation based on 2023 data of the number of international students here in North Carolina. In 2023, again, North Carolina State had the largest number within the UNC system at more than 5,000 international students. The estimated economic impact of these students, again, as you can see, is almost $1 billion to the North Carolina economy. We've already seen declining enrollment for its schools with international students based on current policies. And again, international students also pay just about the highest tuition rates. So again, this does have an impact on our universities. Again, nationally, there are over 1 million international students. And again, this will be impacted as the pipeline to an H1B and other opportunities to remain and work in the US and also remain and advance their education becomes more difficult. William's going to share a little bit more details about the H1B to give you some of the specifics as we dig into, again, the proposed changes and how that might impact this visa category going forward.
Yes, let's talk about the H-1B. A quick overview. The H-1B is the specialty occupation visa. So these are reserved for positions that require a minimum of a U.S. bachelor's degree or its equivalent in a specific or related field. So the foreign national who's applying for this visa must already possess at least a bachelor's degree in a discipline related to the position offered. And the visa is also location and job specific in order to protect U.S. workers. So there is a maximum annual number of H-1B visas that are granted, and that's granted through a lottery system. So this amount of visas was set in 1990, and the annual cap has not changed since. There are 65,000 visas each year for the regular cap and 20,000 for the master's cap. So that means that for individuals who possess a U.S. master's degree or equivalent, there are 20,000 additional H-1B visa chances. So 85,000 in total, with 20,000 being reserved for having a master's degree. This lottery requires an annual registration of employees into the lottery that is run in March of every year. The H-1B, once approved, is granted in 2 3-year increments. So you'll get your initial 3 years and then can apply to extend for a total of 6 years. There is an exception to this based on certain milestones in the green card process and also country of origin for individuals that have higher backlogs when it comes to receiving a green card. So wage requirements and portability, as mentioned, the H-1B is employer and location specific, and that is where the wage requirement comes in. So the employer needs to file the petition and agree to pay the required wage, as well as all costs, both government and legal, and offer return transportation upon termination. So that wage requirement is going to depend on the level of the job, what the job is, and where it is located in order to ensure that the salary is consistent with what other professionals in the field are receiving. Portability is a great advantage of the H-1B visa. It's pretty unique to work visas where a foreign national who's in valid H-1B status can actually transfer their work visa to another employer upon the other employer filing an H-1B petition for them. So it allows for a little bit of job flexibility, provided that the new role is also going to be consistent with the H-1B regulations. And then lastly, the H-1B requires a labor condition application, which Nam referred to earlier, filed directly with the Department of Labor. So this is sort of what announces that a company is considering hiring someone for this H-1B role. It sets that minimum wage and location threshold, and those are available for public record.
And just to give a little context, as William noted, in terms of the number of new H-1B visas each year, I think it was 2 years ago, it might have been the highest number of individuals being registered for the cap. The number of people vying for those, let's call it 85,000, was somewhere around 700,000 applicants. There were some changes to the process over the last year, so it had declined a bit. And I think last year, however, it was still just under 500,000. So you have 500,000 individuals, vying for these 85,000 slots. So certainly we see need across business type and size here in the U.S. for these petitions.
And then, so to caveat all that we just talked about with the H-1B, there are some special situations where the cap or the lottery doesn't actually apply. So the following types of individuals are not subject to that annual cap or lottery system, and this is for nationals that are already in H-1B status. So they've already been counted against the lottery in a prior year, and now they're changing employers or amending their petition or extending it. So you don't have to go through the lottery again once you've made it through once. So then again, that's for nationals who have been counted already within the past 6 years. And then lastly, we have a special exception for what's called cap exempt H-1B petitions. So this is for foreign nationals who work at institutions of higher education or nonprofits that either they directly work there or they're working at a nonprofit that has some kind of special relationship with the institution of higher education. So in practice, this is a lot of how teachers, nurses, doctors receive H-1Bs. And it's a great program because it allows for that H-1B to be applied at any point during the year and to avoid the lottery. And there are some restrictions with those cap exempt H-1Bs. Those cannot be easily transferred. So it's more restrictive, but a great option for individuals who qualify.
Yep.
And then we'll quickly touch on the other visa type, which is the F1 or international student visa. It's often the first visa that many individuals have when they're beginning their career because they're coming to the United States to undergo a bachelor or a master's program at a university here. So F1 students can only work with prior authorization both from their school and from USCIS, the U.S. Immigration Service. Once they have graduated, students are given a year of what's called optional practical training or OPT. So this gives them a year of fairly open work authorization after they have graduated. The work does have to be related to their degree, so it's not totally open, but it's one of the more flexible work options. Individuals who majored in a STEM field can receive an additional 2 years of OPT, so they'll get their initial 12 months and then can apply for a 24-month extension, provided that they had the STEM degree and they're continuing to work in that STEM field. There are requirements for the employer of students on OPT, so there is a training plan that must be developed with specific objections and ensure that there's oversight and control of their work, as well as training. ICE can make site visits to OPT work locations, as well as if a OPT employee is placed at a third-party work site, so it's important to list all of those potential work sites. It is a lengthy process, and there are certain immovable timelines, which is important to keep in mind and strategize with Immigration Counsel when you're initiating this process. You always want to apply early to get those EADs back before graduation, so we always recommend applying at the start of that window. There are some days you can have unemployed while you're looking for a job, but it's not many. So there are a lot of timing considerations for OPT students. And then let's talk about some of these executive orders and things that we're hearing in the news that may have already happened, or they're proposed, or they're rumors. So, of course, there's a lot going on right now. What's been announced, and I think the hottest topic on everyone's mind, is the $100,000 H-1B fee for new petitions filed after September 21st. There was a lot of panic when this was initially announced, and then it was in the coming weeks, it was clarified and sort of reined back a bit to only apply to beneficiaries outside of the United States that were requesting consular approval. There is,
and we're gonna. I was going to say, we're going to dig into that in a little bit more in depth as we continue, but wanted to give you this brief overview to get started.
Yep. So stay tuned. I already see a question on this issue, so we'll be sure to address that soon. In terms of proposed rumors, possible elimination of duration of status for F1, J1, and M1 visas. So this is restricting their visa not to the end of their school program, but to a set date. Notice and comment has finished on that, so we think that we'll hear something soon. There is a proposed weighted H-1B lottery by wage level, which would have a significant impact to the H-1B lottery itself, where the higher wage that you're paying the employee, the greater chance they have as approval. So it wouldn't be even odds like it is now. And then also H-1B wage levels being increased across the board. So the working to increase what the minimum salary is for potential H-1B employees. And in terms of rumors and anecdotal reporting, of course, we don't want to go too much into this, but STEM OPT is policy, so that could be eliminated or reduced, that 24-month extension, and even the OPT program itself, as well as, and we're starting to see some of this now, increased enforcement and compliance for H1B and OPT employees. So that's more ICE visits for students who are working on their OPT program, increased H1B compliance investigations, and increased FDNS site visits as well, making sure that what was put in an H1B application is ultimately what's going on at the workplace. And that leads nicely into the next slide on compliance. So talking about executive orders and actions that are going to ultimately impact what you should be doing as an employer with your compliance. So there's the Project Firewall recently announced by the Department of Labor, which is increased scrutiny on job classifications and wage compliance. Consequences for violating this include payment of back wages, civil money penalties, or debarment from being able to participate in the H-1B program for a specific period. Increased fraud and detection national security or FDNS visits. So this is confirming the presence of H-1B workers at the work site that was listed, as well as their job duties. Third-party work agreements, again, sort of ensuring that what was presented or proposed for the role is actually being carried out in practice. And then just an increase across the board of using requests for evidence to evaluate stricter compliance when it comes to changing employers or amending H-1B applications. So increased scrutiny across the board.
Yep, that's it. And so now we want to dig into some of these questions in more detail and of course, take some of the questions that are being proposed from everyone as well.
Awesome. Yes. So if you would like to add your questions to the Q&A function down below, we can go ahead and get started on some of these. There's already a couple that have come in. I thought we'd kind of touch on exemptions to the $100,000 fee since we had a couple questions about that. So I guess you could start off with, who does the $100,000 H-1B fee apply to, and what is the current status of this new regulation?
Certainly. So as William noted, so the good thing is that when it was initially announced, there was quite a lot of panic. It certainly seemed to apply to every single H-1B holder. Since that time, there have been a series of updated, tweets to start with, as well as some actual memos from USCIS to quantify and qualify exactly who the H-1B fee applies to. So who is subject to the fee is applications filed after September 21st, 2025, which was the issuance of the proclamation, and are basically restricted to applicants who are seeking consular notification or notification at ports of entries. What this actually means is for individuals who are seeking H-1B status who are not currently physically in the United States. So again, maybe someone applying from outside the United States for this classification. So again, it does greatly limit since the majority of individuals are asking for extensions or amendments or changing employers who are already here in the US in that status. It would also impact individuals who, for some reason, are not eligible to extend or amend or change their status from in the United States. And this can be for a variety of reasons. But if the government says, okay, we'll grant your extension, but it's for consular notification because there was some irregularity that makes you ineligible, now those folks would potentially be stuck with that $100,000 fee. Where this also comes into play is we have several clients who have international locations. So perhaps they had someone working here for them in the US on an H-1B, but then they were required to do a long-term project at their work location in another country. That overseas project has ended, and now they want to bring that person back to the US. to continue working for them and use the remainder of that H-1B time. But unfortunately, now they are impacted because, again, even though they had an H, they're applying from outside the US. But all in all, this is good news for cap season, for F1 changing their status to H's, for change of employers. And then we're hoping for even better news as there are several lawsuits that have been filed, and we are waiting to hear about the outcome of that. So I know there was a question about some organizations who have written to the president for an exemption for startups. Again, I don't know whether USCIS will cut out any specific additional exemptions, but again, the whole fee itself is currently, under litigation.
Yeah, and there's sort of the main lawsuit has got an expedited timeline to the beginning of December, so we are optimistic that we're going to know one way or another before March, before the lottery actually runs.
So. And then, William, did you want to talk a little bit about if there are companies that already can seek exemptions, or if there's any
Sure.
process to seek those exemptions?
Yeah, so again, as mentioned, anyone who is already on their H-1B and is seeking to change status in the US, anyone who's in otherwise valid status, and right now they could be changing status to a cap exempt H because they're not subject to the lottery. Those petitions are going through fine. And the majority of individuals who, let's say they're on STEM OPT and already working and will enter the lottery, they will be changing status from F1 to H1B from within the United States. So they won't be subject to this $100,000 fee, even in next year's lottery. There is also a process for a national interest exemption. So company could apply ahead of time, saying we should be exempt for these reasons. I know our firm has filed them, other firms have filed them, and no one has heard anything back yet. So we don't know how that's actually working in practice, but that's another instance. For examples, we filed that on behalf of hospitals for doctors, saying, we believe that doctors in the US benefit the US and should not be subject to this fee. So there are some ways around it. And again, the majority of individuals are not going to be impacted by this policy, provided that they're in the United States already in legal status.
Yeah.
Awesome.
There were just a couple of questions of clarifying about change of status, about from F to H. So for international students who go through the lottery and are selected, so their petition when they file is considered a new petition, but they're asking to change their status from inside the US from F1 to H1B. So in that instance, they would not be subject to this $100,000 fee. So that would be really the key. There are some instances, so this could restrict travel in some instances for international students. We know a lot of times those who are selected in the lottery will ask for consular notification because it allows them to go home for the summer prior to starting their job and then return back in their H-1B status. Again, based on this proclamation, that really would not be an option because that would subject them to the $100,000 fee. In terms of how many people potentially would be impacted by the $100,000 fee, that's really difficult to know because with the H-1B lottery, I'm not aware of specific data that categorizes who applied consular versus who applied as a change of status. It does target some of the really large IT consulting companies that tend to put in thousands of individuals into the lottery who are outside. And so, for example, there have already been a couple of them, Infosystem, and I think Tata Consultancies have already indicated that they will not be participating in the H-1B lottery this coming year.
All right. Well, it looks like we have some questions on wage-based lottery. And
Yeah.
so one question is, what is the wage-based lottery going to look like? Is it like after going through the lottery and if only picked Is the
Sure.
wage taken into consideration? I think I'll just
Yeah,
do that. Yep.
I'll take this one. So it's going to be a weighted lottery. So there's four wage levels for every position, one through four, one being the lowest and four being the highest. So what they're going to do essentially is if you're proposing the employment at wage level one, you get one entry. Wage level two, two entries, three entries, four entries. So you would have quadruple chances if you're being paid at the wage four level versus the wage one. So that's going to severely and disproportionately impact entry level employees. A lot of people who we see applying for H1Bs are they're graduating college and they're of course starting at an entry level pay because it's their first professional job. So this is going to have, I think, a disproportionate impact on F1 OPT graduates. For some companies, if their pay is really great, it could be a good thing because they've got increased odds with their employees. But ultimately, it sort of takes it from being an even lottery to a weighted lottery.
I have another question for you. If the proposed H1B lottery changes are implemented, how does that impact your selection odds?
Yeah, so it will then depend on what your proposed salary is from the employer. So it could increase your odds if you're at a level wages level 2 to 4, or it could significantly reduce your odds if you're going to be at that wage level 1. So proposed wage will become really important. And it also could disproportionately impact where you live as well, because wages are different by where you're living. A wage 1 level salary in New York City is very different from a wage 1 level salary in other geographic areas.
And again, from an employer perspective, right, perhaps a small employer who has one critical employee might be willing to pay an entry level, F1 student coming onto each a higher wage. But if you have larger companies, right now you also get it into issues of wage discrimination, right? If you're going to pay William as an entry level attorney, $250,000 when every other of your entry level attorneys gets paid $85,000 who are US citizens, now you're facing potential issues of discrimination. And we are seeing more compliance issues where they're looking at discrimination against US workers. So clearly, skewing your wage or your proposed salary to benefit foreign national employees at the expense of US citizens, may in the short term help with a lottery selection, but could, create compliance and other legal issues for the company as well. The other proposed rule that kind of coincides with this idea of wage is it's also been proposed to recalculate how those four wage levels are determined. So the Department of Labor each July issues new wages for those levels. Again, entry level, qualified, experience, and advanced. So the proposal is to change the category or the formula in which to determine those wage levels. Under the first Trump administration, they proposed something similar, but it did not have time to work through the legal system. There were some issues with how it was proposed, and ultimately there was a change in administration that stopped this effort. But in the last, those last proposals basically raised every wage level 25%. So for, a wage level 1 now was more than a wage level 2. So again, if you're looking at your wage level 1 going from, 25 to, $50,000, again, the ability to even consider hiring individuals at the lowest wage level, which again is going to disproportionately impact international students, will impact companies as well. Again, both because the business, is not able to absorb those costs, but again, how does that skew in terms of your workforce as a whole?
And is there any data on what the third or fourth level wage looks like in North Carolina specifically that you
Sure.
have?
So it depends on the county and the job itself. So there's an online database where you could look up and see. So it varies a lot both on the county that you're in versus and the job that you're doing.
Awesome. So we have another question kind of on consulting. So during the first Trump administration, getting approval for an H1B for a consulting role became almost impossible. That seemed to be related to the chance the work would change, and it was difficult to tie the application to work at for one specific company. Is that still the same? Have there been any updates there?
Sure. So I think this is really looking at third-party work sites. So, right, I work for company A. I'm seated at company B's office to perform my work. So, yes, under the last Trump administration, we saw some honestly kind of ridiculous outcomes because those contractual agreements between the companies generally have a pretty specific end time. So we saw approvals for 1 month or 2 month based on those contracts. We have not seen quite that return, but I would anticipate we are seeing more requests for evidence generally. So I anticipate that that is likely to continue, and this would be a ripe target for those same sort of issues.
We have another question here. Could you speak on how you are seeing companies change their talent strategies? You mentioned Infosys and Tata won't participate in the lottery. What are you hearing they will do instead? Offshore, change domestic recruiting or retention practices, or just looking for thoughts on various responses from companies and from the universities as well.
Yeah, I know a lot of our clients are sort of in a holding pattern. We're advising them, hey, let's wait and see how this litigation turns out, and sort of hurry up and wait to see what this is going to look like. I know other employers are switching to some strategies, like the L1 visa is a popular option if they have a subsidiary or other entity abroad and someone can work for that entity abroad for a year. They can bring them back on an L1 visa, which would avoid the lottery, and also potentially have green card benefits for the future. So a lot of employers are thinking both in the short term, let's wait, we don't need to make any drastic decisions now, and also sort of disaster planning for the future if this does go into effect. What individuals could we think about alternate work visa options for?
Mm-hmm. And just to build on that, so we kind of gave you the main categories, but again, there's some consideration of can companies work in conjunction with perhaps universities in Canada or Mexico, particularly for work categories like engineer. Those individuals would be eligible for the TN visa classification, and there is no lottery, there is no numbers restriction. If you have a workforce that has more master's and PhD level individuals, are there options to pursue an O1 visa? It's a little bit of a heavier lift, but again, you're not restricted by timelines or lottery as well.
Kind of going on the heels of timelines, what is the right messaging to candidates about timelines, risk, and contingencies without discouraging applicants?
So in terms of not discouraging the applicant, right now it sort of goes back to that hurry up and wait, right? I know it's got to be a frustrating time to be a student about to graduate and looking for those opportunities. Let the litigation do its thing, work through the courts. Hopefully we'll have some more insight there. Again, a lot of candidates are going to be unaffected. If you're already here in the US, you're invalid OPT status, and you would be changing status through the lottery. This $100,000 fee will not apply to you because you'll be applying through that lottery. And also, I think just sort of general advice is to help sort of combat the misinformation that's out there. This proclamation was given, and then the goalposts were moved a lot in the following weeks. It was reined back in after it created that sense of chaos and panic. So, talk to trusted immigration counsel, find out what the facts are as we know them, and that'll help you go into conversations with employers with the most correct information that you can have.
Exactly.
So another question for you. What happens during an ICE or FDNS site visit, and what information are employers required to provide?
Sure. So So FD&S, I'm going to tackle that first. That is the fraud detection unit. It's part of USCIS. So they're the agency that grants the H-1Bs. Generally, they are there to confirm the information in your H-1B or your L-1. Often they do these via email or phone call. So it's really important that your company has a process of who is able to interact with those individuals, whether there's a process for forwarding them, and they're going to want to know all of the details in those applications and ensure that they align with the current status of that particular worker. So if you said that H-1B worker is a software developer who is sitting at a desk in Charlotte, then that is where that person needs to be. And so again, you're wanting to be sure that you are keeping track of your employees who are on visas, where they work, where they're located, and that everything is aligned. In terms of ICE visits, these can really vary. We are seeing more ICE action and the potential for them to come to Charlotte. So as a company, again, you should be prepared. Who is authorized to speak with ICE, and does your company know what their rights are? Without a warrant signed by a judge, not an immigration officer, the company does not have access to any private areas of your business. They cannot compel you to provide documents. And so there are very specific ways in which your company can protect themselves by knowing what their rights are, knowing what the rights of your employees are. We're happy to provide some basic information about what those rights are. And we certainly encourage you to ensure that your company has taught their staff what and who to direct any ICE visits to going forward.
Yeah, and also just to add on that, sometimes, ICE showing up is not always a scary bad thing. Sometimes they're just doing a compliance check on something like STEM OPT. So, in some situations, you've documented the training plan correctly and everything. You should cooperate with ICE and provide those, and they'll do a quick interview and they'll be gone. So, should be prepared for any kind of potential outcome. Like Nam said, it's a great idea to have a designated person who knows what to expect and handle, and who knows where those documents are.
Yep. And then finally, the last, you could also get visited by Homeland Security Investigations. They do worksite compliance. They issue notices of intent, and those are with I-9 audits. The challenge with I-9, right, it's every single person that you have employed with your company, and they are looking for technical violations. So again, if you failed to properly complete the form, check a box, missed a date, all of that is a potential finable offense. So again, internal audits and internal controls are really critical at this time.
All right, we have time for a couple more questions. What is permissible for remote/hybrid STEM OPT work given supervision and training requirements?
Sure. So, STEM OPT or OPT work can be fully remote. It's permissible provided that it is still supervised and the employer has to retain that control over their employment. So, the way to do this is to carefully delineate everything in your I-983 training plan. It's really important to list the home address as the work site for the remote work, because if ICE shows up to the work site that you've listed and someone says, oh no, they work from home, then there's going to be an issue. Now, ICE could potentially show up at your house if that's the work site that you listed, which is a little scary, but that's totally permissible. And that's what should be listed. So remote work, hybrid work is possible, but it needs to be disclosed and it needs to continue to follow all those guidelines of supervision and control. So having a really well-written and updated training plan is the best way to deal with that.
Yep. I see a couple other sort of OPT and STEM OPT questions, so I'm trying to tackle those. I know we have one question about payroll for initial OPT. So the regulations do allow for the initial 12 months of OPT to be unpaid, to have training, and to be classified as an intern. However, technically that has to be within the bounds of wage and labor laws. And again, there are very strict Department of Labor requirements as to what actually can be an unpaid intern. If you are, if that person is doing work that would otherwise be paid, but for the fact that they're on OPT, then that is a violation of wage and labor laws. So again, you want to consult with your employment attorneys to make sure that you aren't violating those rules, but an individual can, on the first 12 months, be unpaid. STEM OPT must be a paid position. It cannot be a 1099. It must be a W-2 employee paid employer-employee relationship that has been created. This is an area where employers are becoming a bit gun shy, I think, because of a lot of the uncertainty. That being said, as William said, if you have, as an employer, that signed training plan for individuals on STEM OPT, and they're following the plan and they're checking in with their supervisors and they're meeting the obligations, from an employer perspective, you've met your obligations. There is no sort of pitfalls or potential liability that you are incurring. Again, if you are meeting those requirements as the employer, reporting to the school, to the designated school officer, ensuring the I-20s are in compliance, that is the student's obligation. That is not the employer's obligation. So any potential issues from that side, again, are not anything that as the company, you would have any liability for.
All right, maybe we have time for one or two more questions. Here's one. We do not sponsor our contracts. They have a separate sponsoring agency. How does that impact us?
I'm not sure, so I'm assuming this means that your H1 workers are cited at your work location by another company. If that's if that is the nature of the question, then again, you are listed as that work site on that H1B, which means, again, if FDNS or ICE comes to the work site location, it would be at your business. And again, you just need to be sure that whatever that contractual agreement between the sponsoring organization and yours is sound and that you're adhering to it. Anytime a H1B or student worker is sitting at a client location, so again, they have another sponsoring agency, that sponsoring agency is their employer for both legal purposes and immigration purposes. So it needs to be clear that you are not doing performance reviews for them, that you are merely allowing them to carry out their work on behalf of that contractual arrangement.
Yeah. I'm seeing a lot of questions on the difference between consular processing on OPT and change of status. So let's touch on that briefly. So most individuals on STEM OPT are going to do the change of status. You're here, you're in the US, you're changing from F1 to H1B. Now, consular processing is reserved for certain situations where something needs to be fixed. So let's say you accidentally worked without authorization or you somehow other violated your non-immigrant status. That can be cured, but it has to be cured at the consulate. So it's cured by leaving consular processing and being readmitted to the United States. So unless there's some kind of complication in your immigration history, most individuals will be doing that change of status. Again, this is one of those situations where you should consult with an immigration attorney because every situation is unique and individualized. Have a consultation, figure out what that's going to look like for you.
All right. Well, is there anything else? Like, are you seeing anything on the in the Q&A, Nam or William, that you want to address, or any kind of final parting thoughts?
I know there were a couple questions. There's one about a consular approved H1B for individuals currently on H4. So It really depends on when that H1B was filed. So I'm assuming the question is you're currently here on H4, you wanted to switch to H1B. If that petition was approved prior to September 21st, 2025, then yes, you could go to your home consulate and get your H1B visa stamp and not be subject to the $100,000.
Yep.
So again, it would be depending on when that petition is filed. I know there was another quick question about premium versus regular processing. Right now, regular processing is taking an exceedingly long time. With the H1B transfer, one of the benefits is that you don't have to wait for that transfer to be approved in order to start with the new company. As soon as USCIS receipts it, you're able to work with them. That being said, a lot of employers and employees feel more secure having that approval in hand. So often it is a business and an individual foreign national decision about premium processing, change of employer petitions. Of note, premium processing is the only H1B fee that individual employees are legally able to pay. So again, this often, is something that can be discussed and negotiated with your employer. And then finally, I think somebody asked about our contact information. It is on the last slide, and I believe Alex is going to share that information. You're also welcome to Google our law firms. Our bios and our individual emails are actually available on our website, so you can find our email on our website. We have our office in Charlotte. We do in-person and virtual consults via our firm here. And we're happy to talk to companies, individuals, anyone who we might be able to assist. It's a tricky time to me navigating a lot of these issues and questions.
Awesome. Well, yes, I will definitely send out a recording of this session today to everyone. I'll make sure to include NAM's and William's contact information as well as a link to their website. But yeah, thank you so much to the Garfinkel Immigration Law team for partnering with us on this awesome and informative presentation. If you have any questions about NC Tech, feel free to respond to my follow-up email or go to nctech.org. And just look out for my follow-up email coming later today. But thank you all so much for joining.